we should get started. It's a little bit after 4 o'clock, and it's my great pleasure to introduce you to Katelyn Atwood, the lead attorney and coordinator for the Vermont Veterans Legal Assistance Project. And if I say that over and over, if I get it wrong once in a while, just, that's what we're talking about. Katelyn works out of the South Royalton Legal Clinic and is funded through this position through 2016 through the Vermont Bar Foundation's Access to Justice program. And Bob, you'll give me a nod or a shake of the head if I'm getting all these names incorrect or correct. And one of the areas that maybe I shouldn't steal all of her thunder, but one of the areas, and she can explain in more detail other things that the Vermont Veterans Legal Assistance Project does, but one of them, statewide, is helping disabled veterans obtain VA benefits. A very, very important work that she's doing and very appreciative. Joining us also to speak will be Tom French, who has been providing assistance with local disabled veterans in obtaining VA benefits. And towards the end of the presentation, towards the end of the hour, Tom will speak a little bit about the process of getting approved to serve in that capacity and what that might mean. And Tom, you can also nod or shake.
I'll take the nod.
Okay, good. You don't have to.
Sage.
I practiced this speech for 3 minutes. So without further ado, I saw a few more people come in. There are materials. Oh, did you? Did we get you back there, Mike?
No, I didn't see it.
You didn't get him.
Oh,
You see that, Deb? I got Mike too. I'm on a crazy roll, and Robin as well. And
I have to start sharing because this is our last one.
a year ago, I didn't know the names behind some of these spaces, and I'm so glad that I'm starting to get it just in time. Yes, thank you. Yes, no. You are silent. You are banished or... Oh, I'm sorry. Stop turning around here.
I stole one.
We're good?
Yeah.
All right, without further ado, Katelyn Atwood. Thank you.
Hi, everyone. Thank you for having me. I got a little lost on the way here, so I'm sorry I'm a little bit late. This is my first trip to Newfane. It's beautiful. So basically what we're going to be doing today is we're going to be doing a brief overview of VA disability benefits. And if we have time at the end, we're going to talk a little bit about getting fees in these cases. If anybody's interested in expanding their practice, this is the area to do it in. And I would encourage questions as we go because I think it creates a robust conversation when we have questions as we go along. And I'm sorry, I didn't realize how small the print was on your handout. So I can email you the actual slides later, and then we can kind of go about it that way. But on the first page here, you'll see what we're kind of, the battle plan for us is we're going to introduce ourselves to the veteran population. We're going to talk about why you should incorporate veterans in your practice. Why is it important that we serve veterans specifically? Why is it important that you market to veterans specifically? It's an untapped market in Vermont. This is something that there's not a lot of, just from Google searching throughout this year, not a lot of firms are marketing directly to veterans. As I'm sure all of you know, there's a limited amount of business for attorneys in Vermont. So this is a great way to get new clients in the door. We're going to talk about why you should be excited about incorporating veterans into your practice. We're going to talk a little bit about the VA, kind of give you a historical overview of the VA. We're going to talk about service-connected disability law in 30 minutes or less. It's going to be a challenge. We're going to talk a little bit about the history of attorneys' fees. Fees beginning at the regional office level, which is the first step to kind of filing a disability claim. And we're going to also talk about Equal Access to Justice Act fees at the Court of Appeals for Veterans Claims. So the last slide on your first page there. There's roughly 22, the American Veterans landscape by the numbers, roughly 22 million veterans in America today. How many of those do you think live in Vermont? About 50,000. About 50,000. So out of a population of about 600 to 650,000 people, that's about 8% of Vermont's population are veterans. So is that larger than what some of you were thinking? Smaller? Larger? So a lot of those, and as you can see here from the numbers, 7.3 million across America from the Vietnam era, 5.5 million from the Gulf War era, about 9 million veterans enrolled in the VA healthcare system. That makes it the largest healthcare system in America. And those numbers are growing, obviously, as people come back from Iraq and Afghanistan when they're hurt. So the percentage, and as we can see from those stats at the bottom, the percentage of female veterans is going to, right now it's about 10%. Female veterans is going to increase to over 16% by 2043, and the percentage of minority veterans is going to increase from 11% to just over 16%. Hispanic vets from under just 6% to over 12%. So what does that mean? That means we're going to have a population that is more diverse and at the same time more needy. Gulf War era veterans, it's roughly 3 to 4 deployments per veteran. So you're talking about 5.5 million Gulf War era veterans, and then times that by 4 for the number of deployments that they're going to see. So these are folks that are going to have a lot of different needs, at a very critical needs, and this is something that we as attorneys can address. What is the oldest branch of the military? Anybody? I like to have trivia. Presentations. No, not the Navy. Nope. The Continental Army. Beat out the Marines by just a few months in 1776. So if we talked
Marine
about.
side is 75.
Huh?
Yeah, exactly.
What?
The Marine side is 75.
Not according to Wikipedia. Well, right.
The Ton Tavern in Philadelphia is 75.
Okay.
Changes there.
Wikipedia tells me the Continental Army, but we'll go with that.
You gave them for some straight soup.
So why should we be excited about veterans cases? Well, what does it really mean to say thank you to vets? I mean, these men and women go through so much agony. Going, they sign a contract and they say, I'm going to lay my life on the line for my country. And I have a quote here from one of my favorite books, from Billy Lynn's Long Halftime Walk. And it's basically kind of sums up this cultural divide between veterans and non-veterans. Less than 1% roughly of America's population is currently in the military. So we really have a divide between civilian life and military life, but yet we've been at war for the longest time period ever. The Code of Federal Regulations defines what wartime periods are for purposes of different sorts of benefits. We've been in the Gulf War era for 20 years. 20 years. That's longer than Vietnam, longer than any other period. So by taking veterans' cases and by marketing to them specifically and addressing their legal needs, helping them access justice, whether it be for a low bono fee, a pro bono fee, or for just a regular fee, helping that veteran is going to help them have that life. So you should also be excited about veterans' cases, because if you take, especially VA disability cases, you are going to win these cases. I'm telling you right now. You are going to win these cases. The VA hasn't really got it figured out yet. They're overwhelmed. We can help them decide the right way. And it's a great thing to be able to write a brief that makes sense, and then a VA adjudicator's like, oh, okay. I get it now. So lawyers win these cases more often. I mean, and it's not surprising. Lawyers win these cases more often than anyone else. So that's why we should be excited. There's a little excerpt down at the bottom of your page there. I took it it's from oral argument from a Supreme Court case, and talking about when the government litigates with veterans, roughly over 50% of the time, the government has taken a position that is substantially unjustified in 2010. It's kind of gone down since then, but it's pretty startling. I mean, the government is going to litigate with veterans more often than not, and they're going to take a position that's substantially unjustified in law. So we can help with that. So let's flip over to page 3. So what is the VA? What is the Department of Veterans Affairs? It's a cabinet level agency. The current secretary is Robert McDonald. It's comprised of 3 divisions. The Veterans Health Administration, so those are the folks that administer all of the hospitals. So White River Junction, all of the CBOCs, the community-based outpatient clinics across the state, all of the medical facilities, that is run by the Veterans Health Administration. It's the largest part of the VA. The Veterans Benefits Administration, which if you take on VA disability cases, those are the folks you're going to be dealing with, is the Benefits Administration. Sometimes you deal with the health side, but the Veterans Health Administration and the Veterans Benefits Administration, they don't really talk to each other all that well. So that's a good thing to keep in mind. The third part of the VA is the National Cemetery Administration. So they deal with all of the veteran cemeteries across the country. That's the smallest portion of the VA.
Is that,
Yeah, no, go ahead.
is that where the $250 credit for vet's burial fees come from?
Yep, so the National Cemetery Administration would be the portion of the VA that would administer that benefit. So what benefits does the VA administer? And so now we're talking about, with the exception of healthcare, we're talking about the Veterans Benefits Administration. We're talking about service-connected disability, which is what we're going to focus on, non-service-connected pension, dependency and indemnity compensation, death pension, healthcare, which is VHA, education benefits, employment training and other ancillary benefits like voc rehab, vocational rehab, and things like that. So who is eligible for these benefits? For any VA benefit, you have to be a veteran with active military service. And this is important to keep in mind, especially for folks in Vermont, because we don't have an active military base here. So as lawyers, it's a really good thing to keep in mind, because a lot of the veterans that I see may or may not have active military service. Because if they're a National Guardsman, they have to be called up to active service in order to qualify for VA benefits. And if you haven't, you're usually not eligible. There's some caveats in there with active duty for training, but that's not usually the case. And you have to be discharged under conditions other than dishonorable. Okay? And that's for any benefit, any VA benefit at all. All right, so let's go to page 4. And if I'm kind of rushing through this because I want to make sure we get in as much as we can, so just stop me if anybody has questions, okay? So let's get the lay of the land. How VA cases travel through the VA and into the court system. So we're in administrative law land here. So everybody, is this a flashback to law school? The first step, though, is we as attorneys have to be recognized by the VA General Counsel before we can even start practicing in front of the VA, because they want to keep track of us. So we have to get accredited through the Office of General Counsel, and that just means filling out a piece of paper, sending it in with a certificate of good standing, and then a couple months later, like usually 4 to 6 months later, they'll send you back a letter saying you're good to go, you can start practicing. So you have to get accredited. A case will then, the first step is to apply to the VA regional office for benefits. So that's, in our part of the world, that's White River Junction is the regional office. They're currently installed in the hospital in White River. They just redid their offices. Do you have a question?
Unless they're a New Hampshire resident, other than me, then you have to go through Manchester.
Exactly. Yep.
I'm sorry, I'm not an attorney. I volunteer for the Disabled American Veterans.
Yep.
I'm a service officer for Legion here.
Mhm.
I'm the coordinator, so I take a lot of veterans out. I help them with some of the things, but I'm
Yep.
really not qualified to represent them.
Right. But yes, so if you're a New Hampshire resident, it all depends on where the veteran lives. So if your veteran lives in Vermont, then they apply in White River. If your veteran lives in New Hampshire, they apply in Manchester. If your veteran lives in Mass, they apply somewhere else. The wide world of Massachusetts. So your case is gonna go to the VA regional office first. There was 1.3 million claims nationwide in 2014. They're on track to be about 1.6 or 1.7 million claims in 2015. So they're busy. They've got a lot going on.
Are those new claims or?
New claims. New claims. The next step is what's called a decision review officer. So that's a person, they have to look at the case de novo. If you ask for a decision review officer to look at a case, they have to look at it with fresh eyes. After that, you can appeal to the Board of Veterans Appeals. You're still within the agency at this point too. The Board of Veterans Appeals is down in DC. There's about 85 judges who decide cases from the Board of Veterans Appeals. Every judge on the board is a lawyer, they're law trained. Every judge has about 3 or 4 attorneys assigned to them as clerks or senior counsel. And they went through about they decided 43,000 cases in 2014. They're on track to decide 46,000 this year. After the Board of Veterans Appeals, you've now exhausted your remedies at the agency, and you can go to judicial review. First step outside of the agency is the Court of Appeals for Veterans Claims. They decided around 6,500 claims in 6,500 cases in 2014 between 9 judges. They're on track to have more than that this year. After that is the Court of Appeals for the Federal Circuit, and after that is the Supreme Court. Okay, does anybody have any questions about that?
What's the standard of review for step 5, for when you get to
We're gonna talk about that. Okay. So, and now we're on the middle of page 4. So now we're gonna get into specifically service-connected disability compensation. What does that mean? The main feature here is it's not based on financial need or income. It's just whether or not you're disabled and you're a veteran. The program aims to compensate veterans for a reduction in their earning capacity caused by their military service. The main thing, has anybody done Social Security here a little bit? Okay, so we've got a few. The main difference here is, like in Social Security, you're either disabled or not. In VA land, you can be anywhere from 0% disabled to 100% disabled, 10% increments in between. So, and it goes by ailment. So you can be 0% disabled for PTSD, and you can be 50% disabled for your knees. Sounds really weird, but we'll go through it. Their disability is awarded in monthly payments. It's tax-free. It's not offset by other income, and age doesn't matter. Again, all we're talking about is severity of disability. So eligibility for service-connected disability compensation. 4 basic elements here. You have to be a veteran, like we talked about earlier. Basic eligibility. For any VA benefit, you have to be a veteran within the definition of the statute. The veteran has to have a current disability, so they have to be disabled right now. They can't be disabled before and then they got better. They have to have a current disability right now. The disability was incurred or aggravated in the line of duty in the active military, naval or air service. And the biggest thing here, and the most litigated thing in VA disability benefits, is there has to be a nexus. There has to be a nexus between your disability and your service. So your disability has to have been incurred in service. So, and sounds a little bit more mushy, than it is. So, is everybody with me so far? Questions, concerns, thoughts? Okay,
If you're representing somebody who's a resident of New Hampshire,
yes.
do you need to be a member of the bar of New Hampshire?
No, because it's a federal practice. So a lot of firms that do this work do nationwide representation. I mean, as long as you're, licensed somewhere, basically, then you can represent veterans nationwide, because you're in front of the agency, you're not in a court. So, now we're on page 5. Step 1, is your client a veteran? So, a person who has served in the active military, naval, or air service, and who was discharged or released therefrom under conditions other than dishonorable. That's a mouthful. So the first thing to look at, federal service, Army, Navy, Air Force, Marines, and Coast Guard. Active service, and Reserve and National Guard, only if you're mobilized, or if you have some active duty for training in there. There's a minimum time in service, but this does not apply to vets who served prior to 1980. 2 continuous years, full-time called to active service, or a service-connected disability. So they don't punish you if you don't make it to your minimum time in service. If you get injured before that happens in service, then you still qualify. So one of the questions down there, is a National Guard member a part of this group? Well, it depends. For example, if you're a National Guard member, Vermont National Guard member who was called up, when were they deployed? Like 2010, 2011, something like that? If you were called up, you're a National Guardsman, you were called up, you served your whole time, or you were hurt, and so you couldn't serve your full time, then you qualify for VA benefits. Practically, what does this mean? If you're an attorney and somebody walks into your office and they tell you they're a National Guardsman and they think they qualify for VA benefits, take a look at their discharge paperwork. If they have what's called a DD-214, that's a federal discharge paperwork from active duty service, then they're in. And if they are, honorable, if they served honorably and all that kind of stuff, then they're in. If they only have what's called an NGB-22, that's National Guard discharge, then it's no good. Probably not. Unless they were injured while they were training or while they were going to and from training. So this can get a little bit, I could do a whole CLE just on whether or not you qualify as a veteran. But the main thing to think about here is active service, federal service. So then we're on the middle of page 5 now. The next step to think about is honorable service. So discharged under conditions other than dishonorable. So there's lots of different designations of discharge, right? I think there's 6 or 7. So this includes honorable, general, or uncharacterized discharges. It does not include other than honorable, undesirable, bad conduct, or dishonorable discharge. So if you've got somebody with an other than honorable, undesirable, bad conduct, or a dishonorable, they are likely not eligible for VA benefits. You could have them go through an administrative process called a characterization of service determination, where the VA can look at your paperwork and say, you know what, your discharge doesn't qualify on paper, but we're going to give it to you anyway, because there's some equities happening that this person should get VA benefits. The last thing to think about is your client a veteran that there's no statutory bars, meaning they were discharged for good of the service, desertion, AWOL, conscientious objector, or if they were subject to a sentence of a general court-martial. So basically, the biggest thing you need to do in this first step is to look at their discharge paperwork and see what's going on there, okay? And I'll email an example around for everybody to look at. So step 2, does anybody have questions about step 1? No, okay, step 2. Does your client have a current disability? Again, your client has to be disabled right now, right this minute. If they were injured in service but the disability no longer exists, then there's no benefits, unfortunately. The disability must presently exist and there has to be a current diagnosis. And the disability can be very minor or very severe, but it has to be present. Okay? Any questions about that? All right. So step 3. And we're on page 6. Page 6 now. Was there an in-service event? So the disability has to be incurred in or aggravated during military service. And it can be just about anything, but the veteran had to have been on active duty. Again, it goes back to, this idea of active service. And the reason why that is because VA benefits are federal benefits. And so if you were injured in service of your state, if you were called up for Hurricane Irene and you were injured, that doesn't get you any benefit, any VA benefits, unfortunately, because you were serving your state, you weren't serving the federal government at that time. So if the federal government is going to pay you benefits, then they want to make sure that you were on the clock for the federal government when your injury happened. So this injury can be just about anything, but you have to have been on active duty, and it cannot be a result of willful misconduct. So if you have a vet, willful misconduct can mean a lot of different things, so be careful there. Or the disability showed itself during a qualifying presumptive period after service. And depending on the ailment, it can be anywhere 6 months to a year, maybe longer. It just kind of depends. So how do you prove this? Medical evidence and lay evidence are the two big ones. And there are special standards if you were in combat and if you have PTSD. So there are different standards there. Other circumstances if they're competent, credible, and probative. So basically, the biggest thing to think about here is you have to be injured while you're on active service, or if you have an injury that was aggravated, that's something to think about as well. Okay? So step 4, the nexus, and this is the most important thing, the nexus between the current disability and the in-service event. They have to connect together. This is the most important and most litigated area of veterans benefits. So there are a couple of different ways to show this nexus. We're going to talk about 4 different ways. So the first and kind of the most logical one is direct service connection. So the veteran has to prove that their disability is directly linked to something that happened during their active military service. And I have a quote in there from 38 CFR 3.303. And I love this quote because the drafters were like, well, we're not really sure. Service connection connotes many factors, but it basically means. So even there we're like, it basically means. So, which is great for lawyers because it gives us an opportunity to be creative, right? This gives us a lot of wiggle room and a lot of creativity can happen here. Service connection connotes many factors, but basically it means that the facts shown by evidence, medical evidence and lay evidence, establish that a particular injury or disease resulting in disability was incurred coincident with service in the armed forces, or pre-existing such service was aggravated therein. So the most, one of the easiest examples to think about, and probably one of the most common ones that I've seen and that a lot of lawyers see in this type of work, is PTSD, right? An incident happens in service, an IED blows up, mortar strikes, something happens, veteran develops PTSD from that event. There's been some really interesting case law about folks who go overseas but never go outside the wire. You can still have PTSD because you feel like you're in danger all the time, even if you're not going on patrol every day. So a nexus can get really fluid really quickly, especially if you have a chronic injury that might not have shown up all of a sudden one day, the veteran got knocked off a tank and landed on his knee and broke his femur or something.
What's the burden of proof?
We're going to talk about that, but it's more likely than not. So 50% or more. So it's actually lower than a civil standard. which is another reason to be excited about VA cases because it's a lower burden of proof than civil cases. So, okay. Another way that you can prove nexus is aggravation in service, like we talked about that a little bit before. But a veteran can be compensated for a disability which began before active duty but was made measurably worse than it would have been had the disability progressed on its own. A lot of aggravation cases are joint cases, so knees, feet, shoulders, back, that kind of thing. If those injuries would have progressed on their own, they probably wouldn't have been as bad if the Marine wasn't jumping up and down off of tanks all day on deployment. That kind of thing.
Does the percentage of disability get apportioned to the degree that it was aggravated versus the degree it pre-existed?
No, typically not. Typically not. What they say is because it would be too hard to do that a lot of times. So what they'll say is, you know, we're going to take you how you're injured, how disabled you are right now. So then over to page 7, presumptive service connection. So this is one that you're going to see a lot with Vietnam vets. So some illnesses and injuries can be presumptively service connected if a veteran can show that the disease appeared within a certain time after service or by showing they served at a certain place in a certain time. So the biggest example of this is Agent Orange exposure. So what the VA basically said was it's too hard for us to decipher who was exposed when and how much. So if you have set foot in the Republic of Vietnam between this date and this date, then you are presumed to have been exposed to Agent Orange. And if you have any litany of diseases or ailments, then you can get service connected for those. So if you've got a Vietnam vet walking into your office with diabetes, or with some weird lung cancer, or with prostate cancer, or skin cancer, any number of cancers, it's likely that they can get service connected for those based on Agent Orange exposure. If you've got folks from Thailand or who are in the Navy and loading and unloading Agent Orange barrels off of ships, that's another way to get presumptively service connected. And those are changing all the time. As more and more records are unclassified, the VA is starting to broaden presumption for folks in the Vietnam era. Okay? So the last one in the middle of page 7 is secondary service connection. This is my favorite one because this is where, again, we can get really creative. So secondary service connection, and this can go a long way in getting vets more money every month, which for somebody who's profoundly disabled, this can make all the difference for them. So any disability that is caused or aggravated by an already service-connected disability can be compensable. So anything that's caused by something that was caused by service can be service-connected. So if you've got a guy with a, or a lady with a knee injury from service, because maybe they fell off of something and injured their knee, and that affects their hip, which affects their back, which affects their shoulder. You can get all of these things service connected, and they can get all the more money for that because of their knee injury. And this is where medical evidence is really, really important, because we all know the body is interconnected. The VA doesn't always see it that way, but a lot of these body systems are incredibly connected. So if you've got somebody who's depressed because they're profoundly physically disabled, you can probably bring in that depression under secondary service connection. Does that make sense? Yeah? Okay. Okay, standard of proof, which we went over already. It's this least as likely as not, so 50% or more. If you're at 50%, if the VA decides we're right in the middle, then the tie goes to the runner. Tie goes to the veteran. And the veteran gets the benefit of the doubt. It applies to all factual findings as well. So it's just another reason to get excited about this, because we have a little bit lower standard of proof. So for service-connected disability, I just listed here some interesting things to be on the lookout for, some things that I've seen, and some things that, you know, if you see this walking in the door, these are probably some underserved folks. So post-traumatic stress disorder and traumatic brain injury, those two usually go together, but not always. There's some new research showing that lots of small stressors, or small, you know, if you have lots of small concussions, that can be just as bad or worse than one major event. There's some new research from there's the National Center for PTSD out of White River, and they're always doing some fantastic, like, cutting-edge research on PTSD. So just because you might have a veteran walking in your office who say, well, you know, I never really had like one specific mortar attack or blow up or whatever, that might not matter. Ask more questions. Were you exposed to loud noises every day? Did you hear things from afar? That kind of thing. Because these small stressors, when you add them all up, they can be much worse than one major event. So military sexual trauma is something that is going to present a lot more often than you think in male and female veterans. And there's some really good case law coming down about how to prove military sexual trauma cases. There's a recent case from the Federal Circuit that recognized that, you know what, people probably aren't going to go and tell their commanding officer that they've been assaulted. Because it's hard, it's embarrassing. And maybe they don't want to talk about it. Maybe it was their commanding officer who assaulted them. So luckily, case law has said, you know, official records are probably not going to exist here. We know that. But so cases can be built on solid lay evidence and medical evidence from mental health providers, or any physical evidence if you can get it too. Another emerging area of service-connected disability is something called Gulf War syndrome. And so if you've got folks coming into your office from Iraq or Afghanistan, who have served in Iraq or Afghanistan, primarily more so Iraq, that have kind of idiosyncratic symptoms. So if you have headaches or joint pain, or if you have irritable bowel syndrome and they've never had that before. So qualifying conditions here are undiagnosed and idiosyncratic multi-symptom illnesses, including fatigue, skin problems, headache, muscle, and joint pain. It might present a little bit like fibromyalgia. Those cases are getting service-connected more and more by the VA. I don't know if anybody saw the New York Times article that made the front page November of last year. Veterans who dug up Saddam Hussein's old cache of nerve agents from the Iran-Iraq war. And they're like, oh, what's this? It's nerve gas. And, you know, exposing that in the middle of the desert can affect a lot of people. So Gulf War syndrome is something that's being looked at more and more. And if you see somebody with a discharge for adjustment disorder, or somebody who was discharged because they were acting out after they got home from deployment, it's probably because they had undiagnosed PTSD or undiagnosed TBI and nobody was helping them. So ask some questions. Talk to them about, you know, when you came back, were you screened for PTSD or TBI? Did anybody talk to you about what it meant to have PTSD or TBI? Were you sent to mental health counselors after you got home? The Army is initiating an investigation where they've discharged probably anywhere from 25 to 30,000 vets over the past couple of years for adjustment disorders and for misconduct. That was a result of rushed screenings for PTSD and TBI where they didn't catch a ton of people and then they started misbehaving, for lack of a better, you know, not showing up on time, not really knowing how to handle their deployment because they weren't given the resources to do so. So look for those things because those are ripe sources for service-connected disability. Okay? So that's going to kind of wrap up the service-connected disability portion of our program. Yes?
Going back to your example, the lower back, the shoulder, do they get extra compensation for each one of those, or is it just one
Yep,
flat 100%?
right. Each part of you will be rated differently. So by an adjudication rater. And that's the other thing we didn't really talk about. So if, say you have, a 10%, you're service connected for 10% disability for your knee, 10% disability for your hip, and 10% for your shoulder, the total of that is not gonna be 30%. I know. So there's, VA math is very strange. That could be a whole other CLE in and of itself. And it's not an average either. Truth be told, I don't really understand it myself. But basically what the adjudication rater looks at is, because of these disabilities, how disabled are you on the whole, is what they try and do. So if you're, yeah, go ahead.
So is the benefit a monthly benefit with the social security disability?
Yep. Okay. Yep. And you can get extra bumps for dependents, depending.
In your example, where you had all three parts on the left were affected, is the likelihood that the benefit would be 50%, taking it as a whole, that there's...
No. No. And it's, every situation is different, because as you can imagine, there's any number of combinations and permutations of different body systems that are considered disabled, and how does that affect the whole person. And the biggest thing that you want to be thinking about with these cases is that the adjudication raters that are sitting down to look at these cases on the first go are not law trained. They're lay folks who are trained specifically in, VA math, VA law. So they're going to look at their manual. They have a huge adjudication raters manual given to them by the VA. You can access it online. It's called the M211MR. It's a fascinating read. And they look at that and they decide, any combination of things, what does it mean for the person that I'm rating right now. So, does anybody have any other questions about that before we move on to fees? Yeah.
You said earlier that the benefit's not based on need or income, but if it's supposed to compensate the disabled veteran for lost income, how can it not be based on their income?
It's not
Is
based,
every body part equal, I guess? Does everybody's arm, is any veteran's arm worth the same amount of money?
yes.
Okay.
Yep.
So a lawyer who's right-handed who loses his left hand, and a contractor who can't work without his left hand, they would get the same compensation for the same injury.
Yes.
I mean, it's not like workers' comp. It's a system to itself.
Right. Yep. And if you the bumps in pay from 10 to 20 to 30 to 40, 50 aren't all the same either. So, and depending on which body system you're talking about, there can be jumps, 20% jumps as opposed to 10% jumps, as opposed to 30% jumps. So it all depends on what you're talking about.
How often, if you know, is the adjudication manual updated?
Weekly, daily. You can sign up for email notifications of the updates, and it's all online. And a company, I forget who they are, just published a searchable PDF of the adjudication raters manual, and you can purchase it for like $200. I think the subscription is like $200 for a year or something like that, and they update it monthly. The PDF is updated monthly, which it's a great tool, and I use it a lot. So, and this, we'll tell you, this is the Bible, the Veterans Benefits Manual. It's put out by a nonprofit called National Veterans Legal Services Program in DC. It's about $170, and it's updated yearly. So this is the Bible on all things VA. So any other questions before we move on to fees? Did I confuse you more?
Is there any risk due to CADA on any issues since you're measuring your current disability?
No, you can always reapply, so.
So lose, and then 2 years later you can say, oh, now I'm really disabled?
Yep. You can, it's kind of like Social Security in that way, you can always reapply. But the trick is but then you lose your retroactive benefit from the date of application if you initiate a new application. So if you've got somebody coming in your office, you always want to make sure you check their appeal dates, because you don't want to have them miss out on any retroactive benefit because they miss the appeal deadline and then have to reapply. Because it's like Social Security in that way, you can get retroactive benefits back to the date of application. So you want to make sure that folks aren't missing those deadlines. But you can always reapply, which is a nice thing. Okay, so now we're going to shift gears a little bit. We're going to move to attorney's fees. So if folks are looking to do these cases for money, this is how it would go. So generally, it's like getting paid in a Social Security case. You only get paid if you win, and you get a portion of your client's retroactive benefit. So the background of attorney's fees in veterans cases, I wanted to give you a little bit of a historical background because it makes sense. It helps you make sense of what the system is now. Okay, so you can see on your timeline there, in 1862, Congress imposes a 5% fee limitation in VA disability cases. So 2 years later, Congress increased that number, attorney's fees, doubles it to $10. No more, no less, $10. 1864 to 1988, not surprising, Congress does nothing. It's absolutely nothing. So in 1988, the Veterans Judicial Review Act allowed attorneys to charge a reasonable fee after a claim was denied by the Board of Veterans' Appeals. So no fees for initial claims. And any violation of that was equal to got you prison or a fine. So they're really serious about this. In 2006, Congress updated the law again, allowed attorneys to charge a reasonable fee when a notice of disagreement is filed at the regional office. So this is where a veteran has filed an initial claim and the VA has come back with a decision that they don't like. You step in as an attorney and file a notice of disagreement, basically a notice of appeal, saying we don't like your initial decision, VA. Anytime after that now, that case is eligible for fees. Okay? The NOD the notice of disagreement must be filed on or after June 20th, 2007. Still no fees for initial claims. So it's hereinafter referred to as the 2006 Act. So the roadmap here is basically, remember the 2006 Act only applies to cases where the notice of disagreement is filed after June 20th, 2007. So for some old cases that have been hanging around, if their initial notice of disagreement was filed before then you have to look to the old law. But by and large, we're going to be talking about the 2006 law. So applicable law here is the 2006 Act, the CFR, and applicable cases from the Court of Appeals for Veterans Claims and the Federal Circuit. So we're going to kind of walk through the who, what, when, where, and why of fees, okay? Above all, the biggest thing to remember here is that the fees have to be reasonable, okay? If you're going to get your fees paid directly to you by the VA out of a retroactive award, then there's a cap of 20% of that retroactive award. But you can take, but right below that, any fee agreement that exceeds 33.3% of a retroactive benefit is presumed to be unreasonable. So basically what they're telling us is you can take up to 33%, lawyers. A third can be yours. Okay? Any fee agreement that is less than 20% is presumed to be reasonable. So there's this weird middle ground where if you take anywhere from 20 to 33%, it probably is reasonable, but if you stay below 20%, then it is reasonable for sure. Okay? I don't know why they worded it this way. I think it's kind of silly. I wish they would have said like 33%, everybody, but no, of course they didn't. You can see there's a bunch of reasonableness factors.
Is that taken away from the client?
It comes out of their retroactive award.
So they're reduced by that amount?
Yeah.
So it sounds like 20% will be withheld for you by the
By the
VA.
VA, if you ask
And
them
the
to.
other, the difference between that and the third has to be covered by a separate fee agreement.
It can be, or what a lot of attorneys do is if they're gonna take more than 20%, they just do a fee agreement with their client, and they don't ask the VA to withhold, and they just deal with their client directly. So, the reasonableness factors are what you would think they would be. They're listed there. Extent and type of services performed, complexity, amount of time the representatives spend, blah, blah, blah. We all know what reasonable means. So who do the rules apply to? 38 CFR 14.636 says, applies to services of accredited agents and attorneys. So that's us. Applies to us. Only accredited agents and attorneys may receive fees from claimants. So accredited agents means your paralegals can practice in front of the agency if they take a claims agent exam. So it's a multiple choice exam that I've looked at the questions and I don't think I could pass that test. But certainly if your paralegals study up, they can become a claims agent and they can practice in front of the agency, which can, you know, optimize your practice in this area for sure. So, accredited agents and attorneys only can receive fees. So then if we're going to the next page, so when can we receive fees? This is the meat of the issue here. So attorneys may charge claimants or appellants for representation provided in the following circumstances. After an agency of original jurisdiction, that's the regional office, the first step in making decisions on claims. After an agency of original jurisdiction has issued a decision, including any claim to reopen, we didn't really get a chance to talk about that, but after an agency of original jurisdiction has issued a decision, 2, a notice of disagreement has been filed, and the agent or attorney has complied with the power of attorney requirements. Basically, the client has said, this is my attorney, and the fee agreement requirements of paragraph G of this section have been met. Okay, so we're going to go through those in order, because that's a lot of information. Requirement 1, agency of original jurisdiction issues a decision. So after an agency of original jurisdiction has issued a decision, including any claim to reopen, but you can charge a fee for a pre-filing consultation, okay? So if a veteran comes in, you can charge for a pre-filing consultation, which means review records, research, counseling, and any other assistance that a potential VA claimant might need, short of actually preparing and presenting a specific claim for benefits. So what this means in practical terms is there's a black hole, basically, from when you can get fees, and you can't, and then there's a time after which you can. So if a vet comes into your office before they filed a claim, you can charge them a pre-filing consultation fee. If you help them file a claim and they win, if the agency of original jurisdiction, the RO, says you win, you know, PTSD 50%, if they win at the first step, no fee for you. If a veteran comes in, they have filed a claim on their own, they've come in and got an adverse decision, you help them file a notice of disagreement, you can get fees. So what a lot of firms do in this area of practice is they just stay away from the black hole entirely, and they just say, until you have a decision from the regional office, I'm not gonna talk to you. And that's what we started to do too, just because the need is so high. So what we typically tell folks is go apply, come back when the VA tells you no, and then we'll help you from there. So that's what a lot of attorneys do.
Who helps them, because I'm sure they need
Yep.
assistance on that first step.
Yep. So the veteran service organizations like the Disabled American Veterans, the American Legion,
And the VFW.
the VFW, those are the big three.
They'll help you file the, fill out the paper. It's up
Yep.
to you as the individual to file.
Right, right. So there are service organizations that'll help the veteran, sit down and fill out the paperwork, but it's up to the veteran to actually file that paperwork. Okay.
Are we talking about fees that would be withheld from the veterans award, or are we talking about
Mhm.
we can't bill them at all? So if somebody comes, you do a free meeting,
Yep.
interview, you
Mhm.
then help them prepare it, you're not gonna get a fee through the VA from that, but can you get it from the veteran?
You can,
Okay, so
you can.
it just means there's a, like a donut hole
Yep.
for the veteran, they're gonna have to pay
Mhm.
upfront.
You can, so yes, sort of. I mean, for the pre-filing, they can certainly pay you before the claim is filed. But again, if they win at that first go-around, you can't collect anything from them.
From their benefit or
Yeah.
from them themselves?
Either way,
Okay, so you actually can't bill them for
No.
that service?
No.
Well,
yeah. Yep, yep. I'm not really sure why they did that.
the veterans can file claims.
Yeah,
Are there fees that you can get that do not reduce the veterans' benefits? That the government is going to pay?
no. The VA isn't gonna necessarily pay you to sue them, unfortunately. Whatever percent of their retroactive award. It might not have to come out of their award unless you ask the VA to withhold it. But the number that you ask them for is gonna be equivalent to whatever percentage of their retroactive benefit that they received.
And is it assumed it will take so long that that will be a sizable, retroactive award is a sizable sum?
It depends on, it depends on what type of ailments your client has. So if you've got somebody who is profoundly disabled and you're going for 100% PTSD, right? They're gonna get a higher retroactive award than somebody who's got 10% for hearing loss. Because folks who are getting 100% for PTSD are gonna be getting, $3,500 a month.
Well, I understand that, but are there some that are going to be resolved so quickly that the retroactive award will be minimal?
It depends, yeah. It depends.
Is there a cap like there is in Social Security cases where it's retroactive percentage, a percentage of the retroactive benefits, but up to a cap, or is there no case?
No, there's no monetary cap. No. There's a cap on, like we talked about earlier, up to 33%. But there's no like it is in Social Security, it's like this or $6,000, right? Yeah, no, there's nothing like that.
Is there continuing disability review if there is in Social Security, so like you get checked every couple of years or something?
They, to an extent, I've had folks who've been service connected, for example, for prostate cancer, and if the VA happens to do a periodic review of your file and says you according to your blood work you no longer have prostate cancer, that's certainly a possibility. But the VA isn't going to be as predictable, I don't think, as Social Security. And so the answer is yes, question mark. There is some disabilities out there where if you're 100% disabled for a certain amount of years or longer, then you will receive that benefit until death. So, yeah.
EAJA money doesn't come out of the veteran, does it?
No, that comes from the government. So, finishing up really quickly, power of attorney, the veteran has to fill out a form saying that you are their attorney, VA Form 2122A, and you have to file that with the Office of General Counsel, with the regional office. You have to file a conforming fee agreement, 38 CFR 14.636G. Talks about the fee agreement requirements, has to be in writing, has to be signed, has to have the name of the vet, applicable VA file number, specific terms under which the amount to be paid for the services of the attorney or agent will be determined. Must specify if the VA is to pay the attorney directly out of past due benefits or not. A copy of the fee agreement has to be filed with the VA Office of General Counsel within 30 days. So all fee agreements may be reviewed by the Office of General Counsel upon its own motion, or the attorney's or veteran's motion within 120 days of the final VA action. And you have to tell your veteran all of these things up front. And there's fee agreements on the NVLSP website. There's sample fee agreements on their website, and I can send those around to everybody as well. So, Equal Access to Justice Act fees, like we were talking about, you can get these from the government in litigation when they have taken a position that is not substantially justified. When you get to the Court of Appeals for Veterans Claims or later, when you're litigating within the agency, no Equal Access to Justice Act fees there. It's only if you take the first step outside of the agency. And there are some. So if you get to that point, now we're on page 12. If you are entitled to both EJA fees and a fee agreement, you can't have both. You can keep the higher of the two, but you have to refund to the claimant the lesser of the two amounts. So just be careful there. They don't want you to have basically a double payday. And once you get up to the Court of Appeals for Veterans Claims, make sure you file your fee agreement with the court as well. So just one closing thought. I have a quote here from Zero Dark 30. So, basically the thought is, there's no one else working on this problem. The attorneys and service organizations are working on this problem, but disabled veterans are going to be coming back for a long time. As long as we are at war, we're going to have disabled vets. And so this is so important. And thank you so much, everybody, for letting me present today.
So Tom, as I understand it, helps, he has a posting at the American Legion and helps the claims come in. Tom, could you explain what it is you're doing?
Yes, I'd be happy to do that. I got into this last spring, starting with the seminar from Katelyn that was sponsored by the Bar Association. And since I was contemplating retirement at the time, I thought this might be a good thing to occupy myself during retirement. Katelyn covered the basics, and I'm surprised she was able to do it in an hour, because I attended, among other things, a 3-day seminar on this subject. And there's much more to it than what she was able to do in an hour. This Veterans Manual is the Bible, as she said, all 2,094 pages of it, and if you memorize all of it, you'll know absolutely everything about veterans laws that exist at the present time. It is a very bureaucratic procedure, and I would have to say that I don't recommend that you do anything other than counsel the veterans in the early stages, because it is highly technical to get through and very bureaucratic, and is likely to be, although I've not had the experience with it yet, extremely time consuming. So I've decided, after a
lot of consideration to try to find an alternative way of getting funding for my activities, and I've decided that I'm going to be able to represent the veterans pro bono for their disability benefits and pension benefits and discharge problems that they may have in their life. So I'm very pleased to be able to do this for them. And but there are a lot of complications involved in this work. So in any event, right now I'm having hours at the American Legion every Thursday from roughly 10:30 until 2:30 with a time out for Rotary, because the Rotary has their lunch there. And but I'm willing to come in at any other time to talk to people about their problems. So far, there's not been a groundswell of activity, but hopefully some of you might be able to refer some work to me, and I've been working with Katelyn, and I'll probably be continuing to do that for the foreseeable future. To give you an idea of how long this process takes, which is another discouraging thing for the private bar, it takes on average 3.5 years from the time that the notice of disagreement is filed until the final adjudication. And of course there are all kinds of limitations on fees, and your fees are not, even if the VA withholds your fees, sometimes the veteran can disagree with that, and your fee, they can issue a notice of disagreement on that, and that means more adjudication before you even get your fees. At the conference, I talked to a firm that was doing this full time, and they said that they've been doing this full time for 8 years. And they're funded because their senior partner happened to get a huge award from the VA. And they're, I think, a 6-man firm practicing in Oklahoma City, and they're just coming now to the point that they're profitable. So this was a word of caution to me in trying to start a practice like this, and why I'm doing it pro bono, because I don't think I'm going to be around for 3.5 more years. So, in any event, that Katelyn gave you a good summary of what this is all about, and I look forward to working with any or all of you who may choose to visit with me. Thank you.
Thank you. So in just 2 minutes, I didn't want to steal Katelyn's thunder at the beginning, and by that I meant the work that in fact she is doing other than disability benefits through this Vermont Veterans Legal Assistance Project. Work, and I'll just make sure I catch you nodding or shaking your head, work statewide that her project is handling. And right now the project is being funded through 2016 by the Vermont Bar Foundation, is veteran-specific issues like disability benefits and discharge adjudications. Some of you may be heeding Tom's advice and not taking this on, but you know that there is this project, and Katelyn is the lead counsel for that, for statewide veterans specifically related claims. In Orange, Washington, Windsor, one more?
No.
Counties representing veterans in civil litigation in general, not veteran-specific civil litigation. So if you have a veteran who could use some representation with folks who are qualified in dealing with veterans, and they're in Washington, Orange, or Windsor County, the project and Katelyn is the place to go. And there's a program regarding veterans and dependents, child support and the like. And that's every a Friday every month in White River Junction?
Every fourth Friday, I'm down at White River Junction providing information on child support. And usually folks come in with family law or child support issues, and then we end up talking about any number of legal issues that they may have.
and these are veterans and a veteran from anywhere in the state. So that's Katelyn's thunder, and aside from the fact that she laid out that information in an hour, some thunderous applause, please. So that concludes the CLE. There were some folks who got here after I went on. There's 2 pieces to getting your CLE credit. I'd appreciate it if you would sign this. And then the certificates are up here, signed by our esteemed treasurer, as I understand is supposed to be the protocol for getting CLE credits. Here's your certificates. And if you would sign, please.